you continue to talk to the police?
Because with the knowledge that I have, it's nothing to trick the police.
But if they had to verify what you said, they had to make sure that what you said was true. How could you trick the police?
Easy.
Overruled.
How could you trick the police?
Easy.
How?
I can't tell you that.
Okay. Were you aware that the things that you talked about were verified?
Sustained. All right, we're gonna take a quick break. Y'all all step back to the jury room for me. Thank you.
All right, from here.
All right, I don't know which, y'all can be seated. I don't know which person.
I'll go out.
You can go out. Thank you.
You say go out?
Yeah, just stick very close. Ms. Melnick, you're going to go out there with him. All right, thank you. I don't know who voiced the objection first, but I mean the motion. Who said they had a motion first? But go ahead.
Your Honor, the way I wrote down in my notes is that the prosecutor said, not a question, but a statement that the police verified inculpatory information from Mr. Copeland. That is not true, by the way. It is questionable whether anything's verified, but obviously jurors make that determination. That is testifying by the prosecution, that is bolstering by the prosecution, that is putting the prosecution's thumb on the scale of the justice, which none of this can be done. This is not the first time that the prosecutors have put themselves in as giving facts before the jury rather than just trying to obtain facts. So I am moving for a mistrial. If your honorable court denies it, I need curative instructions to strike it, and respectfully, if it happens again, it will not be the second time. It's a continuum. So I would ask the court, I know you weren't here, but to keep that in mind as we go forward as well. I'm not moving off my mistrial. I'm just anticipating. No one wants a mistrial. I didn't want a mistrial, but why say that to a witness? So I don't see any good faith in that question.
All right, thank you. Mr. Short.
I adopt everything that my motion is the same. I adopt everything that Mr. Attorney Steele said. I'll also say that in Attorney Hilton's statement that the claims of Mr. Copeland were verified by the police. It's an improper expression of belief by an advocate in front of the jury, and that is improper. And I'll also add, Your Honor, not only do I not believe it to be true, but also there has been absolutely no evidence presented that any of this has been verified.
All right.
So, thank you, Your Honor.
Thank you. Response? Oh, I'm sorry. Yeah, everybody joins. Okay.
When I asked the question, Your Honor, what we will eventually get to with Mr. Copeland, I believe, is that he's the person who told the police initially on the night of the murder about certain facts that were verified. And when I say verified, that we have corroborating evidence to support it. So Mr. Copeland, when he talks to police in June of 2015, he told the police that Mr. Williams rented the car that was used in the murder from,
Can I stop you for just a second?
yes.
It may be that some of the things were verified. It may be you have presented evidence or will present evidence that some of the things were verified. The question that you asked was, did you know that all of the things you told them were verified? So that's the issue.
Okay. And I didn't mean all, but some of the things that he told police were corroborated. Maybe my better
Don't
version
think
should
that's
have
how you said it.
correct. So it was inartful, but what I was talking about is the things that he told police was corroborated by other evidence. And so,
So do you have a response to their motion for mistrial with regard to you having said, did you know that all of the things you told the police were verified?
Your Honor, I would ask that a mistrial not be granted, but that you ask the jury to strike that question, and I can rephrase the question.
All right, you need to be more artful
Yes.
from the get-go with your questioning from here on out, understand?
Yes, sir.
All right, I propose to instruct the jury, remind the jury that nothing that any attorney says in questioning is evidence, and also to strike Ms. Hilton's last question entirely from their minds. Any further curative instructions proposed?
No, Your Honor.
Next, we take a look at a situation where Woody asks the court if he has protection in the form of federal and state immunity, and they tell him yes, even though there's no evidence that any type of federal immunity has been granted to Woody for this case.
Now, did this shooting of Rich Homie Quan's daddy's barbershop start the beef between If Gang and YSL?
The beef was never between If Gang and YSL.
Okay.
The beef was between me, Threat, and Shell Kell. Rich Homie Quan. Because they were Shell Kell was trying to ride Rich Homie Quan. The streets threw YSL into what me and Threat had going on.
Well, that takes me back to the shooting at Lakewood, right?
Can you repeat that?
Sure. You just said that the streets brought YSL into what you and Threat had going on, correct? That's what you just said?
Mm-hmm.
Mm-hmm. Is that a yes for the record?
Yes, my bad.
So going back to the shooting at the gambling house, when you learned that Shell Kell was the one who shot up Thug's vehicle, did you and Shell Kell squash your beef when the two of you met at the Cascade skating rink? When the two of you met at the Cascade skating rink?
Nothing I say could be used in no courtroom,
That is correct.
federal or state.
Is that the parameters of the immunity or?
Nothing can be used.
Correct.
And what your question was?
When you and Shell Kell met at the Cascade skating rink, did the two of you shake hands and say that the beef was over when y'all met at the Cascade skating rink?
I put a gun out on him
At the Cascade skating
at the
rink?
Cascade skating ring.
Okay. Well, who'd you pull it out on?
Shell Kell.
And once you pulled the gun out on Shell Kell, what happened?
I had somebody with me that I didn't want to get caught up in my bullshit, my shenanigans.
Who was with you?
I can't recall.
Now we're going to see where the court actually let Woody testify, even though apparently the court knew that his attorney, Melnick, had been suspended. So they let him testify during the morning. Seems like during lunch he must have learned that Melnick was suspended. So when he comes back from break, he says, "Hey, I don't want to testify without legal representation." And the court says, "Oh yeah, we knew that." But nobody apparently told him. I have no idea how this could happen.
Told that Mr. Melnick been suspended, and I don't want to speak without my attorney.
All right. Let me excuse y'all back again. All right, give us just a second. Yeah, that was brought to our attention fairly recently as well. The thing is, he's going to be suspended for 6 months from practicing. It doesn't have anything to do with this case, but do you have another attorney that you want to engage, or would you like for me to find a volunteer, basically?
I would like for you to find one.
All right. Well, I had already, actually, the public defender's office had been in contact with me to try to find somebody without a conflict, and they have found somebody named Charles Engelberger. So let me try to get in touch with him.
Finally, we take a look at yet another example of Judge Whitaker trying to cover for Judge Glanville to the detriment of YSL defendants. It is clear that Whitaker does not want any questioning relating to Glanville's actions in this case. But as Brian Steele correctly argues, Glanville injected himself in this case when he made statements to Woody to compel him to testify, when he gave him false information about potential sentencing or jail time if he didn't testify, when he said, we need you to testify, etc., etc. So here Brian still brings it up. And we also have a clip where previously Whitaker said that Steele could bring these questions up. Now she circles back around.
I understand what you said, that, no statement. I appreciate what you said. No statement made by the former court disparaging of lawyers should be considered, or whatever the words were. But there's also going to be a jury instruction that nothing that the court says is intimated an opinion. And I disagree in this case with that instruction. I'm going to object to that instruction. And I need the jurors to understand that Judge Glanville, I will make it clear. I will make it clear. I am excluding this honorable court. But Judge Glanville pressured him. And I will argue to the jury that Judge Glanville was biased. And that is admissible because it all happened in front of the jury. And from just Judge Glanville's demeanor, and I'm not here to hurt Judge Glanville. In fact, I like Judge Glanville. But I don't know what happened in this case, but I liked him before this case. But the way he conducted himself to people in this courtroom, I've never really seen a judge do. So I want to ask Mr. Copeland, it is very important to me to explain that he was taken against his desire into Judge Glanville's chambers, that he was with Judge Glanville, Miss Hilton, his lawyer. I'll make it all perfect. If I don't, you could admonish me and the state can correct me, but I'm not here to snowball anybody. But to say that I can exclude statements of Judge Glanville and, most importantly, the conscious or subconsciousness of this witness, because I believe, and I've not spoken with him, Your Honor. I've not spoken with his lawyer about it. But I believe that Mr. Copeland will truthfully say that he believed that Judge Glanville and the state of Georgia are one. And that comes out when Judge Glanville specifically says, and I don't remember the transcript page right now, but it's something to the effect of, we need your testimony. There's no we. Nobody needs anybody's testimony. If he didn't want to testify, I've had witnesses tell me, I'm not testifying. We subpoena them and come to court. They're held in contempt. There's nothing that the judge can do because the judge can't give immunity, so they can't compel the person to do it. So the person invokes their Fifth Amendment and they just leave. That is unfortunate, but that's a reality. There is no we. So with all that being said, I'm making an attorney proffer that if you prevent me from doing that, and Judge Glanville prevented me already, I'm just telling you, he prevented me from cross-examining Agent Racy. He's an FBI agent on misstatements made by the prosecution, knowing the prosecution, it was Miss Hilton, knew that a gentleman who's the same last name as a court reporter entered an invalid, coerced guilty plea. Judge Glanville stopped me again from getting into the truth of that matter. It's never been corrected. The point I'm trying to make to you is that all came out in front of the jury. So yes, I am going to intend to do, I will follow your rule, obviously, but I intend to cross-examine Mr. Copeland, not only what was said by Ms. Hilton, but what was said by Judge Glanville. I will be respectful. I'm not here to, throw some odd names about Judge Glanville. I will just be very specific. And then if he doesn't answer my questions, I'm stuck with his answer of, I don't recall, or whatever has been going on in this courtroom. But I don't believe that you should limit the cross-examination. I didn't do that. All that to me, that was very hurtful to me. And
Yo, what I do, my people? It's your boy, my keys back with the real, man. So y'all basically seen from the beginning of this trial, man, that it's not being fair to everybody involved. From the Judge Glanville, finessing his way into trying to be like a dictator of the courtroom, to being biased, to being on the side of the prosecutors, to really, in his mind, already assuming Young Thug and the rest of the YSL is guilty, man, and not even really giving them a fair chance. Throwing his lawyer, Brian Steele, in jail, holding him in contempt of court because he wouldn't tell where he got the information from of a wrongdoing between the judge, prosecutors, and some other individuals. Man, it's this right here has no doubtly been the most crazed trial I've ever witnessed, man, and it's real unfortunate because you actually got people's lives in the hands of these people. You know what I mean? Like the rest of their lives, man. They're gonna, if they're found guilty, they're gonna hit them with a stupid sentence. And it's just very unfortunate, man. Even if whether you believe they're guilty or innocent, everybody deserves a fair and honest trial. That's what the principles of this nation was, built up on, man. Having trust in the courts to do the right thing. And if you can't have trust in the courts of doing the right thing, man, what really can you trust, How can you have faith in the justice system if they're sitting there, the highest people in charge of everything is corrupt, is bad? And like Brian Steele said in that statement, he said, I've always had a good relationship with Judge Glanville and respected him and thought he'd done a great job, but this trial right here, he's like, I don't know what got into him. I don't know what possessed him to do the things that he did, holding the, the secret meeting with Kenneth Copeland, basically trying to get him to admit the wrongdoing just to, taint the jury and, persuade them to say, oh yeah, well maybe what they're accusing them of is true. It's just being ridiculous, man. And even the prosecutors from their standpoint, they're trying to pull clothes and sheets over the clothes and shirts over the sheep's eyes and trying to dictate them and using, like when she said, what you were saying to the detectives, did you not think they were going to go and verify this information? Then he was like, they can't. And then she was like, well, they did verify this information. And then you got all these objections from everybody in the courtroom because that's wrong. You can't do that. That's persuading the jury. That's putting something in their mind that they can't erase out. That's like you seeing something and then somebody say, hey man, act like you didn't see that. You can act like it, but in the back of your mind, you've seen that and you can't get it out your brain. You know what I mean? For me, I think the jury needs to be, if they don't actively throw this case out, which I think they should, man, but I don't think they do because like I said in the past video, I feel like they want to convict these people so bad that they're going to do whatever they can to keep this trial going. But I feel like they need to get rid of the jury, bring a whole new jury in. And this trial's been going on so long, man. These people, it's not been fair to them. It's not been fair to Young Thug and everybody else involved. They've had to sit in jail over all this bullcrap, this illegal stuff that's just been doing, man, in a just court, in a rightful court. This case would have been dismissed, And it's just very unfortunate that these people have to sit here this time that they cannot get back. You cannot get back time. You can get back money. You can get back material things. But time is time, man. If you look at Young Thug when he first went into jail till now, you'd be like, man, he's been in there for a minute. He's been in prison he's been in jail for almost 2 years with this trial, man. It's been a year and a half, and it's not even done. It's going to go on till next year, maybe even 2026. Who knows? This has already been the longest trial in Fulton County, Georgia history. And it's not been a good one. It's not been a good one for every party involved. It's, it's unfortunate that these people have to go through this. Whether you, like I said, whether you think they're guilty or innocent, they're still human. They're still allowed to have a fair and justice trial. And they haven't been getting this from the start, man. And it's sad because take Young Thug and everybody else out of the picture and put yourself in that situation. You wouldn't want that stuff happening to you or anybody you know or care about or love. You know what I mean? You would want them to get, whether, like I said, whether they're guilty or innocent, take that out of the equation just from the standpoint of having a fair and honest trial. That bullcrap's got to go. You should, and make it the worst, and make it even worse, Judge Glanville is the highest judge in that courthouse. You know what I mean? Everybody reports to him. Everybody asks him questions. Everybody case studies with him because he is the lead dog. That's why he was assigned that case. The biggest case probably in Fulton County history. Of course, he's going to get subsided to it. And it's just crazy. They're on the third judge, man. They're on the third judge. It's been corrupt from the beginning. They've done corrupt things. This stuff just needs to be over with. It needs to be said and done and over with. And just let the man out. He's been put through enough already. Enough injustice, as I say, you know. But I don't know, man. Let me know what y'all think about it down in the comments, man. I appreciate y'all. We at the beach right now. You can probably see down there. Yeah, we at the beach chilling. The condo. You know how we rocking, man. Even though I'm on vacation, I still work, man. My work ethic is out of this world.